Another lawyer texted me about the outburst in court after the verdict. You know, where we heard somebody shout, "Shut up!" I mean, where we had some shouts of obviously happiness, and someone shouted, "Shut up!" I'm not clear on who that was, but would you expect any kind of effort by the defense to try to raise some objections here, or I mean, they haven't shown a propensity to object so far.
Right, and I thought that was an interesting take on it. You know, that particular outburst in the courtroom, would it have an effect on the jury now that they're moving into punishment? Because the jury still has to be objective. They still have to base their decision on the facts. And so if there was too much emotion shown in the courtroom, would the jury now be affected by that? That's going to be a hard argument for the defense to make. I think it's worthy of at least an objection, if for no other reason, to preserve the issue for an appeal. But from what I was able to hear in the courtroom outburst, it was pretty short-lived. The judge pretty much put a clamp on that. So I think the defense would have a hard time making an argument that would stick to get the judge to do something that different than what we expect is about to happen.
Any thoughts on how long we can expect deliberations?
Well, deliberations, it'd be a little hard to know, but I think the evidence phase of the punishment stage will be, I think, shorter than the guilt innocence. I wouldn't be shocked if tomorrow afternoon the jury begins deliberating on punishment. You know, sometimes cases the sentencing can be harder for the jury than the guilt innocence phase, and you know, we'll obviously know it after all the verdicts are in, how the jury felt about Miss Guyger. But you know, there could have been maybe in their mind, let's find her guilty of the murder, let's consider being lenient during sentencing. I've seen that happen in murder cases before.
Do you think we'll hear from some of the jurors? Do you think they'll talk?
That's a good question. Without knowing more about the makeup of the jury, it's hard to really predict that. If you have some outspoken folks on there, you know, I just knowing from other cases from around the country, I'm always a little surprised when you do hear jurors talk, but I guess I really wouldn't be surprised in this case.
If you're the defense, let's start with prosecution. If you're the prosecution, what's the story that you're going to tell in this punishment phase?
That the story you want to reiterate very strongly. This was a man eating ice cream in his apartment. You know, he didn't do anything to anybody. He wasn't armed, and this woman comes through his door with a gun, and 30 seconds later he's dead. You know, how could that possibly happen? And so you focus on that, and you focus on the fact that, you know, his family has lost him. You focus on her lack of complete selflessness in the moments after the shooting, and that's your story if you're the prosecution. If you're the defense, your argument's going to be, look, we can't bring Mr. Jean back, but we can deal with this life.
We can send a message.
We can send a message and still deal with this young life that we have in front of us. You know, is this, you know, this was a horrible mistake. There's no evidence that she was out to get Mr. Jean, that if things had just turned a little differently, you know, both of them, we wouldn't even be here talking about it because nothing would have happened. So are you really going to sentence someone to prison for the rest of their life for a 2-minute mistake, a very tragic mistake, but that's going to be their argument.
Somebody asked, does the jury have to be unanimous on sentencing?
They do. So the same rules apply. So if the jury cannot come up with a number, unanimous number, then a mistrial could also happen. And then you have, what would happen in that sense is you don't go all the way back to the beginning of guilt innocence, you just have a new trial as to punishment. And so it would be a different set of jurors, but you would have to rehash all the punishment evidence again. That's usually less likely, especially when you have a high range of numbers to consider. I would be less. I would be. I'm not anticipating a mistrial at this point.
Somebody's asking about premeditation and murder. Walk us through. In Texas, murder doesn't require premeditation.
Correct. In other states, and you hear it on TV all the time. The premeditation, the planning of a murder. In Texas, you don't need to prove that to get murder, obviously, like in this case. Premeditation, though, if it exists, obviously will go in punishment to, look, you actually planned to kill somebody. You went through, you did all these things, you bought a gun, you stalked the person, whatever the facts may be. And that just shows your heinousness, your callousness, your danger to the community. In a case like this where there's none of that, it's not. You're just not going to even. I would be shocked if anybody even tries to bring it up.
Well, and typically, whenever you have a premeditation to it, we're going to get into capital murder, because capital murder, which carries the death penalty, involves a felony.
Right.
You committed the murder in the commission of a felony, and so that's usually when you get into the elements of premeditation.
Right.
Typically.
Exactly, because you're already committing either some type of crime, other crime, and
robbery, or whatever it is,
kidnapping, whatever. Yeah. So.
Well, can you ever recall? I know you're having to leave here
in
a few minutes.
Sure,
you're looking at the clock.
Yeah.
Tell me how much longer you have. The Castle Doctrine. Have you ever seen the Castle Doctrine used this way? I mean, obviously, it almost turned the Castle Doctrine on its head.
It totally turned the Castle Doctrine on its head, and it would not have even been in the discussion but for the mistake of fact. And so, obviously, the jury didn't go there. But normally, the Castle Doctrine would not protect somebody who's entering somebody else's property. That's just not what it was designed for. It was designed for the opposite. So, if Mr. Jean had killed Miss Guyger under these same circumstances, he would have had the full protection of the law in that instance under the Castle Doctrine, because that's the person. That's the point of view. The Castle Doctrine.
Right, because the Castle Doctrine protects the homeowner.
That's right.
Not the intruder.
That's
in this
right.
case, she was the intruder.
Right, that's right.
And it's also pretty clear that the jury didn't. I mean, you had all this testimony that other people had walked to the wrong floor, parked on the wrong floor, went to the wrong apartment, even somebody who went into the wrong apartment. But they're basically, is your sense that they look at her and they say, you're a trained officer, you're trained to notice things?
I think that's right. And I think also in those other situations, nothing tragic happened. If Miss Guyger was just on her day off and didn't have her gun with her, this wouldn't have happened either. But I think they were looking at her training and say, look, you're a trained officer. Number one, you should have noticed things, and number two, when you got into that situation, you of all people had the training to do something different. Well,
we're going to take a break. We'll leave the stream up because we are expecting this to start back up any moment. The judge had said that they would be back at 1 o'clock. And we're just waiting on it to kick off. Obviously, we're still sitting here looking at this state of Texas seal. So I'm going to let Judge Conyers go, since he's got to go do other work. And I appreciate it. Thank you so much for joining us.
No,
You've been
absolutely.
great this week.
Yeah, thank you.
Well,
Your Honor, before we bring in the jury, there are some pieces of evidence that the state would like to offer up. They're under business records affidavit, but I do believe that the defense will have an objection to them.
What numbers are those?
They're going to be State's Exhibit number 400, 401, and 402.
And exactly what are they?
State's Exhibit number 400 is applicant process unit records from the Dallas Police Department related to the defendant, and it was tendered to the defense attorney and under business records affidavit on August 9, 2019. Applicant process unit records. These are going to be the application file from the defendant's first attempt to apply to the Dallas Police Department.
You said her first attempt to apply?
That's correct, Your Honor. There were two. She applied multiple times.
And 401?
401, Your Honor, is going to be the defendant's personnel file, and this contains, again, also under business records affidavit that was tendered to the defense on August 9, 2019. And this file contains background information provided by the defendant throughout the application process through the Dallas Police Department, including her social media Pinterest account name. It includes the polygraph information related to her application to the Dallas Police Department as well, and statements and things that she's made.
You said a polygraph?
That's correct, Your Honor.
What was the nature of the polygraph?
The defendant failed her first polygraph for the Dallas Police Department.
Well, generally speaking, polygraph...
And not to admit the actual contents of, I guess, the polygraph itself, but the fact that she failed it, and that was part of the reason why she applied the second time. The Dallas Police Department allowed her time to reapply.
Are you alleging that there's something pertinent to the social media?
Yes, Your Honor. There are certain posts that were made by the defendant on her Pinterest account that I think is relevant for the trier of fact to consider. In States 402?
Yes.
That's going to be a copy of the defendant's internal affairs file, a division file from the Dallas Police Department. And particularly within that file, there are certain allegations for misconduct that were sustained against the defendant, or that she received that she received counseling for.
Okay. You've had an opportunity to review State's Exhibit 400, 401, and 402?
Yes, Your Honor.
And may I see those, please?
Yes, Your Honor.
And under what basis are you proffering these?
All purposes, Your Honor.
Which one is this?
That should be 401. This is 402. And then this is 400.
No, I need a few more minutes. Well, let's go in numerical order here. Mr. Rogers, what is your objection to State's Exhibit 400?
Judge, 400 is an application from 7 years ago that, one, it's not relevant. It was so distant in time from the conduct that is the subject of this case. Also, it contains unadjudicated, admissions of unadjudicated offenses and acts, or it contains admissions or references, traffic tickets, smoking marijuana, things like that that are that the state should have to prove each and every act beyond a reasonable doubt. So it has a considerable amount of hearsay as far as the reasons for that she was rejected. That was hearsay from other officers.
Okay, wait, we're talking about
State's Exhibit 400, that's just a 2012 application, Your Honor.
Right.
The other stuff is the personal file, that's going to be
'cause
401.
I don't see any of that.
In State's 400, Your Honor, it mentions the fact that the defendant was denied by the Fort Worth Police Department, and that's the first application for the Dallas Police Department.
And Judge, that's hearsay. We have to. It's hearsay. We don't know the context of what the Fort Worth Police Department decided, and it's not relevant, Judge.
And if I may respond, Your Honor, these are admissions made by the defendant. This is information that the defendant wrote on application seeking employment of the Dallas Police Department.
I found the Fort Worth reference where she is asked, have you ever applied with any law enforcement agency or fire department or related work, including cadet or explorer? And her answer, or the answer was yes. And then it asked for the date, position, and disposition. And she indicates that she applied to the Fort Worth Police Department and was denied to be a police officer. And there was another application to the DFW Airport Police, although it doesn't indicate a disposition.
And that's correct, Your Honor. There are no references in here to any. Oh, here. Have you ever smoked or experimented with marijuana? The answer is yes, on 3 occasions, beginning in July of 2009 and ending in June of 2011. There's a supplemental concerning the drug usage where there's an indication that it was never purchased by her or never possessed more than 4 ounces.
First time she was right out of high school with friends. And then allegedly 2 times in 2011 at someone's birthday, a friend's birthday. And this was completed on August 23rd of 2012.
That's correct, Your Honor.
And Mr. Rogers, your objections to 400?
Just her admission that she was denied by the Fort Worth Police Department is not relevant. It's more prejudicial than probative. Her admission to marijuana usage and the subsequent discussion of that in the application process, again, is not relevant and more prejudicial than probative.
Let's look at 401.
Yes, Your Honor, that's the personnel file. And the state, I know it's quite voluminous, Your Honor, and the state, in order to not create a situation, and especially in regards to the polygraph, the state, as far as 401, there is a page in there that mentions the defendant's social media accounts where the defendant self-reported which account she had and the names of those accounts. If that is the only page of state's 401 that the court would allow, the state is fine with that.
Okay, so just so we're clear, allegedly this exhibit,
State's 401.
contains 334 pages.
That's correct, Your
And
Honor.
there are a host of flags that you...
That's correct, Your Honor. And I can point out exactly which one is the social media if the court would like.
Well, I see you have a
Tag
tag
that
in your
says-
social media. And I'm presuming that the city of Dallas did the redaction of the
Yes, Your Honor.
identifying information.
That is correct.
Place it first. Okay, so where you have social accounts, all of the pages subsequent to this, how many pages?
No, Your Honor, just that pages. Where
Just
it
this
lists-
one page
Where it lists down here.
where it lists Pinterest,
That's correct.
Groupon,
That's correct.
and is it Score Center?
That's correct. And the usernames for those different accounts.
Of this entire personnel file, you want this one page? Have you?
There's more information in there, but I believe, as the defense has mentioned, that there are some objections to other things, and including, more specifically, there was the polygraph that the defendant, that's listed within that State's 401. The relevance or the purpose for the polygraph is that the defendant failed her first polygraph, but that, of course, was related in connection to the usage or the recency of usage, amongst other things.
So the examiner asked the question if, I think it was 2011 was the last time you used, let's make sure everything. If your last marijuana usage was 2011 in June, is that the question that she failed on the polygraph?
It's that in subsequent, so there's 2 polygraphs, there's different dates given, different time frames that are given, and then maybe some mentioning of any other sort of I guess, crimes that may have been committed.
In the polygraph? That were not identified on this application?
That's correct. There aren't any crimes at all, Your Honor, but it's just self-admissions and self-reporting to.
Did the examiner elicit what the crimes were?
Yes, it was self-reported, Your Honor. And it wasn't actually, so we're discussing a theft that occurred at her prior
It was
business location. She worked at TGI Fridays.
She admitted she stole or took a pencil and a brownie without permission.
And so those things were what led to the issues with the polygraph.
A pencil and a brown.
That's correct, Your Honor, and the state's not wanting to admit, not
So
wanting
you're
to
not-
get into any of that. That's correct.
Well, let me be clear. You want to proffer that she failed the polygraph, but you don't want to say it was for the theft of a brownie and a pencil?
Well, if the court will allow such things, then the state can, but we don't think that that's really a pressing issue.
Okay. It's hard for me to line up with this polygraph. What are the pressing issues from?
Those were the only things with the polygraph, Your Honor, in the personnel file.
Okay. And you want this single page that identifies 3 social media
Yes, Your
outlets?
Honor, that's correct.
Score, Center, Groupon, and Pinterest.
That's correct.
Mr. Rogers.
With regard to the, I'm kind of unclear, but if we're,
I haven't made decisions.
Right.
I'm inquiring, trying to understand the
if she's
scope.
just offering one page from the personnel file that you just identified that has the 3 social media accounts, then I don't have an objection to that.
To that portion of her personnel file.
That one page.
No objection to the one page identifying the social media account.
That's correct, Your Honor.
That's all you want out of this personnel file.
Yes, Your Honor.
Okay, that'll save me some time in reading all of this. Okay. State's Exhibit 402.
State's Exhibit 402, Your Honor, is also from the Dallas Police Department under Business Records Affidavit, dated for August 9, 2019, and this is the Internal Affairs Division file related to the defendant. And particularly within this file, the state would like to admit before the jury the sustained allegations against the defendant based on departmental violations.
Do you have those flags? Because this is another voluminous exhibit that
Yes, Your Honor, I can tell you exactly what there was. There's control number 2018-183.
hold on, you have some tabs here as well,
Yes,
but they're not marked as they were in the first one.
that's correct.
Is the blue one significant? Or? Oh, you got pink, blue?
Yes,
and
they're
green.
just different, yes, Your Honor.
Okay. Let me just go to the first pink tab. Are you there? Oh,
I am. I was gonna say, if it's okay for the court, I can direct you to the ones exactly, because they should be listed in, okay. The first one, Your Honor, is going to be the defendant received a sustained finding through an internal affairs investigation for adverse conduct, violating Dallas Police Department Code of Conduct, and it's going to be under control number 2018-183,
Okay.
which should have a date of September 24, 2018.
Yes.
And this is the
I'm there.
control number that resulted in the defendant's termination of employment with the Dallas Police Department.
I'm sorry, restate that again.
This control number and violation is directly resulted in the defendant's termination of employment from the Dallas Police Department.
This one, which identifies, all I have on here is January 11, 2017 DVR program violation.
And that's another one, Your Honor.
Counseling. September 25th, 2017, a chase policy violation.
And that's another one, Your Honor.
Okay. So I get, you mean the page behind?
That's
this
correct.
page?
Yes, Your Honor.
I'm sorry, but I'm failing to see.
Mine, though.
So here's the first blue
Yes.
tab up to the next green tab.
And there, and that's why I said I can give you the list of the dates, because the way that we received it from the police department would be helpful for the court to have the dates so that you can pull those out.
Well, I want to know exactly what it is from this
Okay.
that you wish to put in the evidence. So Mr. Rogers can be well informed and make objections he'd like. Mr. Rogers, you have a copy of the disciplinary action that took place on September 24th, 2018,
Yes, yes, Your Honor.
and your objections to that?
Yes, Your Honor. With regard to investigation control number 2018-183, the report contains actions completed by other officers and reports of officers that is hearsay within hearsay. The report also contains Garrity information derived by my client that normally the district attorney's office has redacted, but in this case, there's a page there's a part of the investigation which says what Amber Guyger summarizes Amber Guyger's internal statement. That's a violation of Garrity v. New Jersey.
Wait a minute, I haven't seen this.
The Garrity information.
I
been
haven't read
redacted.
every document she just handed me for this investigation, but I have not seen the Garrity information as of yet.
Garrity information has been redacted from the state's file, just so that the record's clear. The defense received the full file.
Just when I see what they offered.
The first section she gave me, I've gone through. I hadn't gone through the second section, but in the first section, I didn't see any Garrity.
Judge, under investigation, it says officer testimony. It's a summary of her internal statement.
I don't see the officer testimony.
It says, Judge, it says officer testimony.
I know that's what it says, but it just lists, it just states September 9th, Officer Guyger was placed under arrest in Kaufman County by the Texas Rangers and booked into the Kaufman County Jail for the charge of manslaughter.
Right.
That's the sum total of officer testimony.
Right, that's my client's statement. That's the internal statement provided by Amber Guyger on whatever date that was.
This is her statement. She said to them, I was arrested.
Right.
You don't think they could have found this information from some other source?
I know they could have,
There's
Judge.
not a reference
To any statements that are made.
except for this heading.
Well, Judge, I can, normally they redact that because that is the investigator's submission of the summary of Officer Guyger's internal statement. Whether they could get it, of course they could get it from other sources, but they included it in there, and that is a violation of Garrity v. New Jersey. The statement that she gave was she was told that that statement, nor the fruits of that statement, could be used against her in any criminal proceeding.
I don't understand how this is her statement. It is literally a factual recitation of what happened on September 9th, 2018.
Right, Judge. They asked her to give an internal statement asking her if she was arrested. They gave her the Garrity warning, and she gave a statement admitting that she was arrested.
Judge, and the state doesn't, defense attorney is correct that typically, and as is followed in this case, for public integrity, the file is redacted of Garrity. Neither have any of the prosecution teams seen any Garrity statements made by the defendant. I couldn't even tell you what was in a statement, let alone, I guess, that there was in fact one.
Judge, that is a summary of her internal statement. I know it's short, but it's in it. And
I'm having a hard time grasping that this is testimonial or provided subject to interrogation, because it just states on a date certain she was arrested in Kaufman County by the Texas Rangers and booked into the Kaufman County Jail.
right above that, Judge, it says internal. No, just the.
I see the heading.
Officer testimony.
It
Is that?
says investigation, officer testimony. So you want to object to this paragraph where they summarize what allegedly happened on September 9th.
They are
categorizing that as her officer
The way they write those investigations, Judge, and I've seen hundreds of them, is they're going to say, here's what the officer testimony is related to this. The only officer testimony in this case was Amber Guyger's, and they put her statement in their summary. That, regardless of what information is in there, it still is a violation of Verity v. New Jersey. And Judge, we don't have the actual investigator here, I think it was Sergeant Criddle here, to explain the context of the investigation. Furthermore, it contains, hearsay, the booking. Well, are you offering this?
No.
So
I'm presuming you want these 1, 2, 3. 4, 5.
she was fired because she was arrested for manslaughter. And so we don't.
There's another page that says essentially that.
I guess, for your honor, if the defense is concerned with these documents going before the jury and actually being taken back, the state will withdraw State's Exhibit number 402 out of an abundance of caution. But what the state would like to do is still talk about the pages that list whether or not there was a sustained finding for an allegation. That is a one-page that looks like
It is 1 page.
it's a one-pager. There's no other information. It just states what the violation was and whether the allegation was sustained or not. Like this right here. Oh, okay, I'm sorry, Judge.
Well, so this is the statement of Major Ramirez with his findings with internal affairs, and so the information gleaned in here. One is that it implies that there was some type of investigation into this adverse conduct, and that it leaves open. We don't know what Major Ramirez's thoughts are.
Let me see that first portion that you provided to me.
And also, it's just the fact that there was a warrant. We know she was arrested. The fact that there was a warrant for manslaughter and that she was put into the Kaufman County Jail. The ranger has already testified in response to whether or not he believes today there's probable cause for that same offense. And the findings of Major Ramirez are hearsay, and the actual conduct and acts that it's talking about are the fact that she was arrested for manslaughter and booked into the Kaufman County Jail, and that's more prejudicial than probative.
Here is so you allege that part of the administrative investigation included testimonial evidence from Ms. Guyger. Is that correct?
Yes, Your Honor.
All right. Would this be sufficient that this portion here that begins, as a result of her actions, Officer Guyger shall be held accountable for the following rule violation. And then they state the code of conduct violation, and then their findings. So in essence, in these last 2 paragraphs, this sentence, and that doesn't have any testimonial or alleged. I have the rest of this. I was reading through it, and there are references to testimonial evidence. If you take the last paragraphs from that page, I guess you need to redact whatever else is preceding that. And what are your objections to the portions that I've excised?
Judge, I object that these are the findings of Major Ramirez with the Dallas Police Department. So it's hearsay within hearsay. And so we don't have the context of the alleged rule violation, what he considered, and
But the rule is concisely stated there.
right.
In essence, can't quote it verbatim, but I think it's conduct that reflects negatively on the department.
Right.
Words to that effect.
Right, and part of his,
And it just goes on to state, you've been arrested for the offense of manslaughter. And that's conduct that is unbecoming to the department. And as a result of that, being terminated.
it's a conclusion made by Major Ramirez that it's hearsay within hearsay, and it violates the confrontation clause, and I don't have the ability to cross-examine Major Ramirez on the context of the rule violation and elicit testimony regarding that. Additionally, it is not relevant, the fact that she was fired from her job. We're not trying to say that she's still a police officer. The fact that she was arrested for manslaughter and booked into Kaufman County Jail is more prejudicial than probative, unless I have the opportunity to call the ranger and respond.
And Judge,
Wait. Everybody that faces a felony indictment somewhere along the way is arrested.
Right.
So your argument that that's prejudicial, more prejudicial than probative, is overruled. Now, I've tried to excise out all references to any testimony. The portion that I have directed you all to simply states what the rule is and what the finding is.
Right.
Your objection to that will be overruled
Well,
in as
Judge-
much as that is part of the business records affidavit that accompanies 402.
Thank you.
Is there something else
Nothing
in that
else.
big old stack of stuff?
Nothing else, Your
So,
Honor. That the
We
state would
have
plan.
fought for a half hour about the fact as to whether or not Ms. Guyger was terminated, but I want to make sure. I didn't rule on the application process. And I thought I was writing down your objections to 400. I don't think I did. Let me go back. As to 402, your objection that that's too prejudicial is overruled. The excise portion, I'm asking you to redact.
Yes, Your Honor.
And just so we're clear, you know what I'm talking about,
Yes, Your
Mr.
Honor.
Roger?
Yes, ma'am.
At the very bottom? Yeah.
Right.
Okay. So you'll redact that.
Yes, Your Honor.
That will be admitted as to 402. 401, you have no objections to the social media accounts page. It identifies some other things, but the pertinent identifying information has been redacted.
Right, so just that one page,
And
correct?
just take a look at that one that we're talking about.
Right.
Just so you can see it.
I don't know where.
I'm good with that, Judge.
Well,
I mean, I've seen it.
Anyway, and back to the initial application. Now, the initial application, you indicate that our application was denied for a multitude of reasons. Is that correct?
That's correct, Your Honor.
And
Or at least it just states that on. That's it.
I don't think they give a reason.
No, the defendant self-reported denied at Fort Worth, and then that was her first time with Dallas Police Department. She was not accepted at that time.
Do they have rules that tell you?
They not specifically, no, Your Honor. The only other thing listed in that would be the marijuana usage.
And Mr. Rogers, I thought I had written down your objections to the first application denial.
There's the fact that she was denied by Fort Worth PD is more prejudicial, is not relevant, and it's more prejudicial than probative. And the marijuana usage is not relevant and more prejudicial than probative.
And the state's response, Your Honor, is that this is punishment-based. The trier of fact can consider all information. I think especially in guilt innocence that there was discussions about our victims' marijuana usage.
Okay. I'm going to allow you to use state's 400. Your objections are overruled. Okay, I'm sorry. I know you all came in here and waited at 1 o'clock thinking we would have started right at that time. I wish we would have. Does anybody need a bathroom break? Because we're going to go until you all are done. Well, I mean, any of the attorneys. Okay, great. Let me ask her to bring the attorney.
No, Judge, just 1 second, because if we're going to keep going, we want to make sure we get all these objections to the other evidence before we start.
Oh, okay.
Sure.
Sorry, Mama.
That's okay.
Judge, the defense and I are discussing, can I approach the bench?
Yes. I'm sorry, you said the objections were what? I'm sorry.
Judge, one, that's a different account name than is the social media that identified that on the state's exhibit as one of her social media accounts. So, Judge, I object that they can't link it to a post actually made by my client to they can authenticate that those comments were actually posted by Ms. Guyger, that anybody could have posted to that. There's nothing unique about other people have access to your page, and so I think they need to show with certainty from forensic evidence that is tied to that there's no other way that anyone else could have posted that under that name. And three, it's more prejudicial than probative.
Can I see State's Exhibit 401, page?
Your Honor, my response to that is those documents were actually pulled off of the defendant's Pinterest account via search warrant by Ranger and had been tendered to defense counsel in discovery a long time ago. Just you have to go through and really look at what's on that. Go through the search warrant return to find what's in there. There were almost 1,000 or so images on that return, and we're only asking to offer 3.
So just so I'm clear, you all got a search warrant to search for the contents of Ms. Guyger's Pinterest account.
Yes, Your Honor.
And these are things that Ms. Guyger saved to her account.
Yes, Your Honor.
And they were provided to the defense. Did you
Yes,
receive
Your
them
Honor.
as part
Yes.
of your discovery?
Yes, Your Honor.
And you object that they're prejudicial.
Yes, Your Honor.
The objection is overruled.
And then last, Your Honor, the state would like to re-offer, and I think we've renumbered them, were text messages that were discussed in guilt innocence, which we marked as states 353, 354, and 355. The court at that time would not allow us
Is
to...
this the MLK and...
Yes, Your Honor.
Let me make sure I read these. Objections to 353, 354, 355, and 356.
Approach, Your Honor.
Yes.
Other individuals within that exhibit so I would object to those statements that other individuals made as hearsay, and the text responses from Ms. Guyger are not relevant and more prejudicial than probative. .354, Judge, again, there are texts that are coming into the phone that are hearsay, and any responses by Ms. Guyger with her phone, these text messages are not relevant and more prejudicial than probative. The probative value in both those exhibits is substantially outweighed by the prejudicial effect. In State Exhibit 355, the hearsay statement from Martin Rivera we would object to, and the response by Ms. Guyger is not relevant, and its probative value, if any, is substantially outweighed by its prejudicial value. In State's Exhibit 356, there are hearsay text messages from Martin Rivera, and the text responses from Ms. Guyger are not relevant, and the prejudicial value, the probative value, is substantially outweighed by the prejudicial value.
Ms. Long?
Your Honor, the statements made by the defendant are statements made by the defendant, therefore are not hearsay, and they are relevant because the jury can consider any statements that they may consider relevant to determining the appropriate punishment in the trial. As far as the statements made by the other individuals on the phone, those statements are not being offered for the truth of the matter. Sorry.
Your objections to 353 through 356 are overruled. They'll be at minutes. Does anybody need a bathroom break? Thank you. You all may be seated. Ladies and gentlemen, thank you for your patience. Will the state make an opening statement as we begin the punishment phase?
No, no.
You may call your first witness.
State calls Ms. Allison Johnson.
Thank you. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
Thank you. Please make yourself comfortable.
May I proceed, ma'am?
Oh, yes, please.
Please state your name and spell your first and last name for the court reporter.
Allison Jean, Allison Jean.
And Ms. John, where are you from?
I'm from St. Lucia
And how long have you been in St. Lucia?
all my life.
What do you do in St. Lucia?
I am the Chief Executive Officer for the National Utilities Regulatory Commission. It's the commission that regulates water and energy in St. Lucia.
Can you tell the ladies and gentlemen of the jury a little bit about your family dynamics, your family makeup?
Well, I came from a single-parent family. My mom raised three of us. I'm the eldest of the three. I got married at the age of 23, and I've been married for 30 years now. That's the most difficult part to say, but I have my daughter, Elisa. I had her before I was married, and then I had both of them 10 years later, and then Brant.
How old is Alyssa?
Alyssa is 37.
Okay. And when was both of his birthday?
Both of them's birthday was this past Sunday.
And how old would have both of them been?
He would have been 28 years old.
And how old is Brent?
Brant is 18.
And tell the ladies and gentlemen about your husband.
My husband and I have been married for 30 years. That's the only husband I know. We are Christians. We worship at the Church of Christ in St. Lucia. So we have a simple life, one of faith, and that's how we raise our children in the church.
Let's talk a little bit about that. Let's spend some time talking about both of them. Can you tell them what type of student was both of them?
Both of them went to elementary school in St. Lucia. At the age of 11, there's an examination that is called the Common Entrance Examination. That is what allows students to go into high school. It's a competitive examination. And in the year that both of them sat that exam, he ranked 23rd on the island. There are about over 4,000 students who write that exam, and he was 23rd. So he was admitted to what is known in St. Lucia as the top high school. It was the St. Mary's College. During his 5 years at high school, both of them was very active. He was president of his schoolhouse. He was also the leader for several little clubs, several groups. He started a choir because he loved to sing, so he got one of his teachers to commence a choir, and he was the one leading in that choir.
Was that in high school where he got the teacher to start a choir because he wanted to sing?
That's right.
You know what I Coach?
Yes.
Ms. John, I'm going to show you some photos. And I'm showing you it's been marked for evidence as State's Exhibit 325, 326, 327, 328, and 329. And are these photos, or some of the photos of your son, both of them?
Yes, they are.
Okay. And do you think these photos would help the jury to understand your testimony as you're discussing your son?
Yes, they will.
Say this, 325, 326, 327, 328, and 329 to the bench of investigation.
No objection.
They're all admitted. You may publish them at your discretion.
Thank you, Your Honor. Now, Ms. John, who is that handsome young man right there?
That's my son. That's both of them.
And if you could, pull that microphone just a little bit closer to you, so the court reporter as well as ladies and gentlemen can hear you, okay? Ms. John, do you recall when this photo was taken?
Yes, this photo was taken when both of them was vying for president of the school council at the Harding University.
We're going to come back and talk a little bit about that, okay? And State's Exhibit 326. Who was that?
Yeah, that's both of them. It was at my retirement function, which the staff had for me. It was a surprise for me, but both of them was there. I worked in the public service of St. Lucia for 32 years, and I retired as permanent secretary in the Department of Infrastructure. And this is the function that both of them attended.
Now, you said that you're retired, but we started off talking about you're working again. How did that come about?
That's right. I left the public service very early, and I now with the regulator, which is a statutory organization, so it's not a full-fledged public sector employment.
In States 327.
This is at Bofum's high school graduation, and he's with his grandmother. The trophy that he has in his hand was awarded to him, and it's called the Spirit of St. Mary's Trophy. This is the trophy that is given to the top student, and it's given for discipline, for dedication, for academic excellence, and for active involvement in extracurricular activities.
And you say that this is his grandmother. Is she in court today?
Yes, she is.
And I'm going to skip to State 329.
That's Botham with his little brother Brandt. We were in the Cayman Islands at the time. We were on vacation, and we were at a turtle farm. So that was Botham in the background and Brandt in yellow.
And then States Exhibit 328.
Yeah, so that's a photo of both of them with my daughter Lisa and her husband Brandt, and at the time her two boys. Her two boys are my two grandsons. She now has 3 sons.
Now let's talk a bit about the age difference between Alyssa, Botham, and Brandt. What's the approximate age difference between the 3?
It's about 10 years.
And how did Botham and Alyssa and Brandt interact with that age difference apart?
Yeah, both of them was my middle child. And so he brought Alyssa and Brand together because Alyssa and Brand are 20 years apart. So I always referred to him as the glue to my 3 kids because he was able to relate to Alyssa and bring Alyssa to Brand and vice versa. But Botham was he also was this take charge type of person. So he was always giving advice, both to Alyssa and to Brand. Although he was the younger brother, but he treated her like he was the older brother. And it was more so because he was bigger and taller than her. So he assumed the role of big brother, although she was 10 years older than him.
After high school, what was Botham's decision to do?
Botham, after high school, he also did 2 additional years in St. Lucia, and he also worked afterwards at a manufacturing company in St. Lucia. But his desire was to go to university in order to study accounting. My preference was for him to study accounting in the West Indies, which is close to where we lived. However, Botham was a very headstrong child, and he preferred to study at Harding University, which was in Searcy, Arkansas. And the primary reason he said to me was it was a Christian university, it was related to the Church of Christ, and he would have gotten an opportunity to continue his singing while he was at university.
When Botham decided to go to Harding University, had Alyssa already left St. Lucia?
Yes, Alyssa left St. Lucia about 18 or 19 years ago. So she was already in the United States, and she was a citizen of the United States then. So Botham felt that he wanted also to be closer to his sister. So that was another reason that he chose Harding University as opposed to a university in the West Indies.
Was he always good with math and numbers?
He was very good. He was good with math, good with accounting, although I wanted him to do engineering. But he just had his head made up, and he really wanted to do accounting.
So let's tell the ladies and gentlemen about when you took Botham to Harding. How was that experience?
Yes, we visited Harding in April of 2011, I believe. It was a weekend that they had Spring Sing, which was a sort of a concert. And from the time we got to Harding University, from the time we got to the campus, Botham looked like he was already admitted. So he would just leave me seated somewhere and say, "Mommy, I'll be back." And he was just all over the university. He had already made friends on that, just that weekend. And when I saw the way he behaved on the campus, in my mind, I'm saying I cannot disappoint him. I have to find some way of getting him to Harding, although at the time I felt that Harding was very expensive. Coming from the Caribbean, we do not have United States dollars. We have Eastern Caribbean dollars, which are $2.70 to a US dollar. So it would be expensive to be able to pay in US dollars. But seeing how elated he was, I had no choice but to accept that he would go to Harding.
So as a parent, you made it possible to let your child go to the university you wanted to.
That's correct.
Can I approach you? Showing you States Exhibit 333, 334, and 335.
All right.
Do you recognize those photos?
Yes, I do.
And will these photos aid you in further discussing both of them at Harding?
Oh, yes.
State tendering to defense 333, 334, 335.
No objection.
They're admitted, I'm sorry.
Permission to publish, Your Honor?
Yes.
Now, Ms. Jean, let's talk a little bit about Botham's time at Harding. What type of activities did he do while at Harding?
In addition to his academic studies, he was involved in the Good News Choir. It was a Good News Singers, which is a choir that go all over the United States singing. He was also, I think, an intern or something at the Rock House. He was involved in the youth ministry. So he did a lot of missionary type work, involved in sometimes doing preaching, singing. He also told me that he was part of a group called Bisons for Christ, and they went to several places helping people, helping the elderly, going out and clean people's homes. Because of his IT background, he assisted elderly people in setting up their computers. He told me he had set up a computer for an elderly couple so that they could have Skype contact with their children. So he did a lot of these activities.
Ms. John, you mentioned the Rock House. What is the Rock House?
The Rock House, I believe, is an organization that does outreach work. So they help other students. And he was one of those who was supposed to be encouraging the students to attend worship. So that was one of the responsibilities he was given. He was also part of the rugby team at Harding.
What was that?
Rugby, the game rugby, yes.
Okay, I'm going to show you what's been admitted as States 333. We see Bolton.
Yes.
Okay. And he has on the shirt that says college.
Yes.
You talked about him going on mission trips. Is this a picture from one of his mission trips?
Yes, this is a trip that all the others who are in the photograph are students with two adults from Harding. So he brought these students to St. Lucia. The background is the Boys Training Center, which is a center for delinquent boys in St. Lucia. And when he brought his fellow students and that team to St. Lucia, they concentrated on reaching out to these delinquent boys, together with an orphanage that they visited and many other institutions, but mostly institutions that had people who were at risk in some way. So the elderly home, the elderly folks' home, the orphanage, and delinquent boys. He concentrated a lot on serving these people.
How many years did Botham and his classmates from Harding come back to St. Lucia to do mission trips?
There's so many.
Oh, I'm sorry. Yes, ma'am. How many years did Botham and his classmates from Harding come to St. Lucia to do mission trips? Do you recall?
There are many, because he started 1 year after he went to Harding University, so that's 2012. And since then, they have come every year. 1 year they came twice. So there seem to have been about 7 or more trips to St. Lucia.
And then it states Exhibit 334. Is that just another group of a picture of the group that was in St. Lucia?
Yes, I'm not sure if it's the same year of the first photo, but that's a group of the students that came to St. Lucia, and they're at a sky ride park. So he took them.
Is it zip lining?
Zip lining, that's right.
And then States Exhibit 335.
Yes, that's the group that came in the spring. And both of them, together with Jake, the one with the white shirt on the opposite end of both of them, led, yes, the two of them led that team that year. The two adults were not there during that time. And that's a photograph taken in front of the church that we worship at in St. Lucia.
Commissioner Cochran?
Yes.
I'm showing you what's been marked for identification purposes. States Exhibit 330, 331, and 332. And are these photos of both of them?
Yes.
Son?
Yes.
And will they aid the jury in understanding your testimony as you're giving?
Oh, yes.
States tendering to defense 330, 331, and 332.
No objection, Your Honor.
They're admitted.
Commissioner Cochran?
Yes.
I'm showing you Ms. John, States Exhibit 332. When was this photo taken?
I think this photo was taken about 2 years ago. Might be 2017, but I know for sure it was taken in Jamaica, where both of them attended the annual Caribbean Lectureship of Churches of Christ. So he was a song leader, and every year the Churches of Christ meet in a different Caribbean island, and this time it was in Jamaica.
And so you said he was a song leader. Explain to the ladies and gentlemen of the jury what his roles and responsibilities were as a song leader for the conference.
Yes, so because both of them sang very well, he was placed as one of the people who would be leading the congregation in singing. So that Caribbean lectureship had members of Churches of Christ all over the Caribbean, the United States, in some cases England. Many people attend that lectureship. So both of them was selected for many years to be on the program for that lectureship.
And I'm showing you what's been marked as States Exhibit 330. Do you recall this photo?
Yes.
Tell us a little bit about States Exhibit 330 and States Exhibit 331.
The first one with the lady is, again, one of the people that both of them reached out to in the community. Both of them found out that this lady's birthday was on the same date with mine. That was March 11th. So he went to visit her with his friends, and he just went to sing with her and just made her happy. There's another photo, that has a cake. So he brought her a cake, and he just stayed the afternoon just singing with the group.
And prior to doing the mission work, had he known her in the past?
No. He just walked around the community and he just reached out to the people who he thought needed help. So he cleaned her backyard, and then they just sat there and he just sang with her.
And then in State Exhibit 331, Ms. John, did your son have a passion for helping others?
That's right. This is actually a blind man and another person that he went to visit. And what he's doing there is singing to him.
And this is also on the island of St. Lucia?
It's in St. Lucia, yes.
Now, Ms. John, I want to talk a little bit about the day that you were notified that Botham was no longer with us. Do you recall where you were?
I was in New York with my daughter at 12:30 a.m. on September 7th when she came to inform me that she had gotten a call and that somebody told her that Botham was shot and that he died. Thank you.
And when you received that news, Ms. John, how has your life been since that particular day?
My life has not been the same. It's just been like a roller coaster. I cannot sleep. I cannot eat. It's just been the most terrible time for me. I'm not able to work, but I just try to busy myself just to see if it will get out of my head. But it's been very, very, very difficult.
And so, since this incident has occurred, you haven't been able to go back to work?
I went back to work in January of this year, but it's very, very difficult. I've been sick often, and I have to try to keep the family together because everybody's in pain. I've had to seek counseling every Tuesday. I have to get a therapist to come in and help. And I try to pray and fast and do all sorts of things just to help me get by.
What about Grant? How was the relationship between Botham and Grant before September 6th of 2018?
Botham and Brant had a very good relationship. Actually, Brant spent the summer of 2017 with Botham in his apartment here in Dallas. And when Brant was leaving, Botham called, crying because he didn't want Brant to leave. He felt that Brant spent 3 weeks with him, and the first week he said he had a lot of work to do, and he really regretted that he didn't spend enough time with Brant, and he really wanted him to stay.
And how is Grant processing?
I'm very concerned about him because he's just been very, very quiet. In the beginning, he was just punching down all the walls and everything, but now he's gotten quiet.
And have you been able to get help or counseling for Brandon?
He's been doing some counseling, but he doesn't speak much. So I'm not sure what's going through his mind.
And what about your husband? How long is the relationship between both of them and your husband?
Both of them, again, felt that he was the one to give advice. So his dad preaches as well, and he would call his dad, especially on a Sunday, and they would go over the sermon, and he would also always tell his dad, like, why didn't you do the sermon this way? Why didn't you look at it from that way? And why did you use that? Didn't you use that scripture? And why didn't you? So they were very close. We had a very, very close family. Very, very close. Both of them once surprised me for Mother's Day. I didn't know he was coming. I was sleeping that Sunday afternoon and I heard his voice. He used to call me Gigi. That was short for Governor General. He said I was his Governor General. And I was sleeping and I heard Gigi. And I'm like, but that's Bofam's voice, but maybe I'm dreaming. So I closed my eyes again. And he just came and lay down on me on the bed. He flew all the way from Arkansas at the time. And he came to St. Lucia to surprise me.
With him in Arkansas. And at one point, Alyssa was in, was it North Carolina?
North Carolina.
How did you keep the family together when they were so far apart?
I always made it my duty to spend time with all of my children. So both of them, Alisa was in the US and I always spent Christmas with Alisa. And both of them came for the summer. So at some point over Christmas, both of them would leave Arkansas and come to North Carolina. So we all would be together. So I would take Brand up and we all would be together, either in New York or in Arkansas.
At one point, both of them took an internship with PwC. Do you recall that?
Yes.
Did he tell you about that process and how he got into that job?
Yes.
Can you share that information with the jury?
In 2015, both of them came to Dallas to have an interview for that internship. Both of them called me crying, and I thought there was something wrong. And he said, "Mom, I made it for the internship." There were 12 people interviewed, and I think they were going to be selecting 6. So he was very nervous. He didn't think that he would have made it. And he was selected for the internship at PwC. And during the time he was on the internship, it was supposed to be for 6 weeks. But he was offered an extension for 6 months. And he was still studying at Harding then. So he was offered an extension to 6 months and also gotten an offer of employment to start in June or July of the following year. So he spent 6 months here in Dallas from June until December. He returned to Harding in January, graduated in May, and then came straight back to Dallas in June of 2016.
Did you ever come to Dallas to visit Botham?
Yes, I did in December of 2016. I came to visit Dallas. I came to visit Botham with my mom and my nephew, and we spent 3 weeks with him during Christmas time.
And during that time, did he have to work as well?
Yes. He was working in Austin. He would travel to Austin on a Sunday and return on a Thursday or Friday. So the first week that we spent with him, he took us to Austin. And he put us up at one hotel and he stayed at another hotel. He said it was because he didn't want us to disturb him because he was still at work. So he didn't mix business with pleasure. He stayed at one hotel and he said, "Y'all are on vacation, I'm not." So, but we had a good time with him.
Ms. John, when was the last time that you saw Botham before he passed away on September 6th of 2018?
I saw Botham on the 2nd, 3rd, I think it was the 1st, 2nd, and 3rd of February in 2018. I was in New York, and Botham came across to New York to visit me. His dad was there as well, so that was the last time we saw him.
And how was that visit?
Beautiful. Again, he believed he surprised me.
You knew he was coming.
Yeah. So, but he told everybody not to tell me. But a little bird told me. So.
And when was the last time you spoke with him on the phone?
I spoke with him on September 5th. That was the day before. He called about 9:30 in the evening. So that's when we last spoke.
And this past Sunday was his birthday?
Yes, September 29th.
What have you done to try to cherish his name and the things that he was most fond of?
Yeah, all the things that Botham started, his outreach to the delinquent boys, the orphanage, the elderly home. We've started a foundation in his name, the Botham Foundation. And on Sunday, we launched the foundation at a gala event here in Dallas. We expect out of that foundation to reach out to other people. And in addition to these institutions, we've added the outreach to victims like ourselves, to lend support to them so that they can cushion the pain that we're going through. So that, we could help them in whatever way.
And on Sunday, Mrs. John, how old would Botham have been?
He would have been 28 years old.
So in his short 28 years, he dedicated himself to helping others?
Actually, 26 years he did that.
26 years, I'm sorry.
Yeah. Because he died a few days before his 27th birthday.
I have no questions.
Unless you be excused.
No objection.
Thank you very much, Ms. John.
State will call Carrie Ray.
raise your right hand, Mr. Ray, to be sworn. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you very much.
You may proceed. Thank you. Mr. Ray, would you please introduce yourself to the jury by your first and last name?
Kerry Ray,
And would you please spell it for the court reporter?
Kerry, last name Ray, Ray.
And Mr. Ray, how did you know Mr. Jean?
I was his coach, which is basically his direct boss, and then he also worked on my engagement.
Okay, and now I see you speak a little fast, and so the
Okay.
court reporter has to take down everything that you say, so if you would just slow down a little bit when you speak.
Sure.
Now you say, so you were his coach, and where did you coach him at?
So the coach is essentially, we have a line of reporting. So coach is the first level of reporting. So I coached him on just work-related matters or anything that he wanted to talk about.
So I hear you say work-related matters. Did you work with Mr. John?
I did.
And please tell the jurors where you guys worked.
PricewaterhouseCoopers.
And Mr. Ray, what do you do for PricewaterhouseCoopers?
I am a senior manager in our risk assurance practice. So we work on, basically work on controls and compliance.
And what did Mr. Jean do at PricewaterhouseCoopers?
He did the same. He was an associate.
And Mr. Ray, when did you first meet Mr. Jean?
I met Bo during his internship, which would have been about 4 or 5 years ago.
And what stood out to you about Bo?
Mostly his attitude. Just very nice, personable, lit up a room. He got along with everybody. He was one of those guys when he started his internship, we immediately felt comfortable with him.
And so you immediately felt comfortable. Was it a feeling that we have to have this guy?
Oh, well, for me it was, definitely.
And please explain to the jury why you felt that way.
Yeah, well, I mean, what we do is very relationship focused, so we work with a lot of different people. And not only was he very personable, he was also very sharp.
And what do you mean by very sharp? Because
He was-
and maybe some of the jurors, what exactly do you do at PricewaterhouseCoopers?
I mean, we do a lot of different things. So when I say he was sharp, he's very intelligent. So if you just think about an auditor. I mean, I know most of you guys have heard that term. We're an auditor, just not, we focus on a bunch of different regulatory and compliance matters. So it's a field where you need to use your brain a lot and you need to solve problems. And he was very good at solving problems as well as working with the client.
And so you said that you were his coach. What were you helping to coach him on?
All right. So everybody has a coach. I have a coach, but it's basically just you're developing. I've got 3 or 4 of them, and you develop them through their career. So you want to encourage the things that they do very well, and then you want to help them work on the things that they don't do so well.
And was Bo the sort of man or employee that did things well?
He did things very well.
Was he receptive to criticism if there was something that he might need to work on?
Very, to a fault, I would say. He was always looking to improve himself.
Always looking to improve himself. Would you say was he a go-getter?
Oh, definitely. He always wanted to do more.
And you met him in the internship process, so at some point in time there was an offer for employment extended to Bo. Would you please explain to the jurors how that process and discussion came about?
Yeah, so I mean, you do an internship, depending on what university or program you're in, determines when you do your internship. In his case, it was his junior year. So yeah, he received an offer, soon after or before his internship ended. So in many cases, we'll offer a full-term employment at the end of the internship.
And is employment with PricewaterhouseCoopers competitive, would you say?
Oh, very.
What were, around the office, if you could help explain, what was Bo's typical day like, if there is such a typical day at PricewaterhouseCoopers?
So there aren't a lot of typical days. But a general day would be, so we go through different phases, but, a typical day might be he shows up to the office or to the client site, give me or whoever he's working for on the engagement an update, and then for the rest of the day he'll be working through his engagement. So he'll be meeting with clients and completing his deliverables so that we can deliver our work.
And what was Bo's specialty?
So, I mean, Bo had he was strong in the IT space. So,
What?
in the IT, so information technology space.
Okay.
So, he was very strong with applications and systems, and that's where he shined.
And what about the point of sales?
Yeah, so, and that's part of the IT space. But yeah, so there are certain engagements where we work on different applications. A POS system may be one of them, but that's definitely an area where I would look to him for his expertise.
And would you say Bo made an impact on PricewaterhouseCoopers and specifically the Dallas location?
Yes and yes. I mean, his impact on the Dallas location was outsized, right? So, I mean, everybody knew. I mean, a lot of people knew Bo, and anyone who knew Bo had a very high opinion of Bo.
It's just because of the type of man he was.
It was the type of person he was, just his almost his aura. I mean, when he went to a meeting or he joined your group or whatever it was, you knew Bo. He was just big personality, nice person, big smile. Never really had a bad thing to say about anybody. That's the kind of person he was.
And how has his passing impacted you and your fellow coworkers at PricewaterhouseCoopers?
It's been rough. So, I mean, I used to see or talk to Bo on a daily basis for, 3 years I knew him. I mean, our group has had a very difficult time coming to terms.
And what do you mean by that?
It's just not seeing him on a daily basis, or not having that guy to lift you up. I mean, it's been tough.
And so did he provide, you said lift you up, so I'm guessing was Bo also a sense of comfort and support?
For me and for many others, definitely.
What, I guess, when was the last time you saw Bo?
Probably. I mean, the week he died, I saw him that week, or the week before. So I was at a conference the week he died, but we spoke every day while I was away. That's just that was our relationship. So he worked on my engagement. We spoke by phone, text, emails, and I just remember sending him a few messages on the plane while I was getting ready to take off that night, and I know by the time I landed, he was no longer with us.
Was Bo, and you said, so I'm guessing work seems very important to him. Was he a person that finished his tasks by the time that you needed them done?
Yes. Bo is a perfectionist.
He's a perfectionist?
He's a perfectionist. So Bo, he wanted everything to be perfect. So, I mean, that was just personality. He wanted it done right. He wanted it done on time. And, I didn't worry about anything that Bo was working on. Did
you see a bright and long future for him at PricewaterhouseCoopers?
100%. So I paid a lot of special attention to him. And I target several people in the firm that I want to make sure I work with and develop, and he was definitely number one on that list because I knew he had whatever it is he wanted to do in the long term, whether it was with PwC or not, that he was going to be excellent at it.
And he was going to be excellent at it.
Yeah.
What would you say his potential was like?
Unlimited. He was, yeah, I mean, he could write his own check, I think. He had his own path to go.
I'll pass the witness.
No questions.
Thank you very much, Mr. Ray. You may be excused.
No objection from the state.
Oh.
State will call Robert Watson.
Swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Make yourself comfortable.
May I proceed, Your Honor?
Yes, please.
Good afternoon, Mr. Watson. Sergeant Watson, you look a little different today.
Yes, ma'am.
But you are, in fact, the same Robert Watson that testified for this jury last week.
Yes, ma'am.
And Sergeant Watson, we called you back because you were the defendant's sergeant for the CRT team. Is that correct?
Yes, ma'am.
And I guess that would put you in sort of an immediate supervisor position.
Yes, ma'am.
And I brought you back because I wanted to ask you, in the years that you spent with as the defendant's supervisor and sergeant over CRT, did there come a time where you made an internal affairs affair referral based on some actions taken by the defendant?
Yes, ma'am.
And would you please explain those to the jury?
It was regarding an incident where Ms. Guyger had an individual in custody, and she was by herself, and the individual got away. He got up and ran away. She called for assistance, and other officers showed up to help her.
And this incident that you're referring to, did this occur in August of 2018?
That sounds about right.
Okay. And so you said it was a situation in which a individual got away. Was this a handcuffed prisoner?
Yes, ma'am.
And so did this handcuffed prisoner escape away from the defendant?
Yes, ma'am.
And did the defendant notify the immediate supervisor?
A supervisor was on scene. He wasn't made aware that it was a handcuffed prisoner.
He was not made aware?
Yes, ma'am.
And when were you notified that a handcuffed prisoner had escaped from the defendant?
Several hours after that incident had occurred.
And based off of, at the point in time when you learned of it, you felt that this was some information that you needed to make a referral to the Internal Affairs Division?
Yes, ma'am.
And that this was something more than just a situation that you could do verbal counseling for?
Yes, ma'am.
I'll pass the witness.
Sergeant Watson, how long did you supervise Ms. Guyger?
Whenever she started the CRT team, I was a supervisor then.
Okay. And overall, during the time that you supervised her, was she a dependable officer?
Yes, she was.
Did she work hard?
Absolutely.
Did she come into contact with numerous violent felons on the CRT team?
Yes, sir.
Did you trust her as far as her character with regard to being on your team?
Yes, sir.
With regard to this incident, there was a suspect that had been arrested. You know what the suspect was arrested for?
I believe he had illegal narcotics on him, if I recall right.
And there was no indications or allegations that Ms. Guyger used any inappropriate force with this suspect, correct?
No, sir.
The suspect was handcuffed, and somebody let their guard down for a minute. And if you let your guard down, I mean for a second, then this is what could happen. The guy ran off while handcuffed, correct?
Yes, sir.
Now, there was efforts made to immediately find this guy, correct? The suspect?
Yes.
And was that what everybody's immediate attention was on?
Yes, sir.
And a supervisor was out there, correct?
Yes.
And the supervisor, I guess, was informed that a suspect had escaped, correct?
Yes.
But the supervisor wasn't notified with the specific words that a handcuffed prisoner had escaped, correct?
Yes, sir.
At any time you have a suspect escape, especially handcuffed, you're going to want as a supervisor, it's your duty to inform the chain of command by requesting further investigation, correct?
Yes, sir.
And it's a not just for disciplinary purposes, but also for training purposes, correct?
Yes, sir.
And their officers are on a daily basis a number of interactions with suspects and prisoners, and even though Ms. Guyger has dealt with numerous violent felons, your concern was that, okay, just we can't let our guard down for any second, and there needs to be clear communication afterwards. Is that fair to say?
Yes, sir.
Is this the type of violation in and of itself that would lead to serious discipline?
Not that I've ever seen, sir.
I'll pass the witness.
Briefly, Your Honor. Sergeant Watson, were you on duty that day?
I was not.
Where were you? Were you at?
I was on a day off, yes, ma'am.
Okay. But there was an on-duty supervisor, is that correct?
Yes, ma'am.
And the defendant did not notify that on-duty supervisor?
True.
She notified you, is that correct?
Yes, ma'am.
And you said you found out several hours later?
Yes, ma'am.
Is there a mechanism in place to where if there, we'll strike that. When you returned to duty, why did you feel it was important to make the referral instead of just doing verbal counseling?
Because we're required to notify the chain of command when a prisoner escapes custody.
And a prisoner escaping custody, especially one handcuffed, isn't that, that's a serious situation that the chain of command as well as the safety of the public need to be aware of. Is that correct?
Yes, ma'am.
I'll pass the witness.
No, further.
May he be excused?
No objection from the state, Your Honor.
No objection.
Thank you very much, Sergeant.
They called Alyssa Finley.
Sorry, who's that?
Alyssa Finley?
Make yourself comfortable, Miss Finley. You're still under oath.
Yes. Ms. Finley, you're the same Ms. Finley that testified earlier this week in trial, is that correct? Or
Yes.
last week, I'm sorry.
Yes, I am.
Tell the ladies and gentlemen of the jury about your relationship or what you have observed with your parents since your brother has passed.
I know my mom, well, my entire family just hasn't been the same. My mother, she's different. She cries a lot. Most of the time she would call me. We try our best to comfort each other, but it's really hard because sometimes she calls me on a bad day where I'm low. For Bertram, I would describe him as just a shell. Because it's like the light behind his eyes are off. He's not the same.
When you say he's not the same, his attitude and his demeanor is not the same?
Yes, he has always been like both of them, a bubbly type of person, and he's not that way anymore. Sometimes you speak with him and I don't even know if he hears.
And you currently live in New York, correct?
I do.
Has this caused you to go home and check on your parents more often?
I call them more often. Yeah, I make it my duty to call my mom or text her at least, every day, a few times a day, because I know that was always a concern for her with both of them to always have contact. So again, even though I'm low, I would still make it my duty to reach out to her, just so that she knows that I'm okay.
And how has this affected your younger brother, Brant?
Brant is another shell. He has always been a quiet person, but even now he's even more quiet. I know both them and I, we've had conversations about Brant, about, bringing him out of his shell. When both of them visited Brant, my mom spoke of, one time both of them went into his car and he called me crying, like, Brant doesn't want to do anything with me, and he felt like he let Brant down because he left. So they didn't get more of an opportunity to bond. So he was very emotional about that. And so I don't know. I'm worried about Brent.
Tell the jury a little bit more about your relationship with both of your children. You have 3 boys? Correct?
I have 3 boys.
And what are their ages?
14, 11, and 4.
And did they call him Uncle though?
They called him both of them. He tried to demand that they call him Uncle, but he was both of them.
How are they processing life without both of them?
When I told them what happened, it was the 7th, it was a Friday. They just went back to school. School started the 6th in New York, and every Friday they have a half day. So when they got home, I made them sit down and I told them what happened. Jaden, he's a lot like Brant, an introvert. So he cried, but his way of coping is every time both of them came to New York, he would leave some item of clothing for Jaden. So Jaden would wear, even though it's way too big for him, he would still wear it. His hoodies, t-shirts, he would wear them. Jareem, he's 11. Jareem, now he is scared of police officers. One time I picked them up from school and he came running scared, and I was scared because I thought something was wrong with him, and he came into the car and like, what's going on? And he said he just saw a police officer, and that frightened him. Jordan, if he walks by a photograph of both of them, he would say, oh, there's both of them, because both of them always used to sing with him. Jordan likes to sing, even though he's 4, and both of them would always sing with him. So.
How often would both of them come to New York to visit you?
Anytime he got the opportunity. And it would be for the weirdest reasons. He always wanted a reason to come to New York because he loved New York. When I closed on my house, September 2017, that was a reason. So he came, and I spent his birthday with him. He would come for Christmas, Thanksgiving. Any holiday, we tried to spend it together.
And we heard your mom talk about how both of them thought he was the big brother.
Yes.
Would you say that you spoiled him? Yes.
I did. I think so. I would say I'm overprotective when it comes to my family, and both of them, I treated him like one of my boys, one of my children. So when he was attending Harding, he would call in the middle of the night for me to order a pizza for him and have it delivered to the dorm. So I would do it. If he wanted a new phone, he would call me. I'm like, fine, I will give it to him. So yeah.
And in fact, he was on your cell phone plan until he got a real job?
For a while, up until it was 2018. He tried to convince me to add him back to it.
But he was also very generous with you as well.
He really was. When I closed on my house and he came on his birthday, 2017, he asked me to take him to Best Buy, so I did. And it was for him to buy me a TV as a housewarming on his birthday.
And was Botham very active in his church here in Dallas?
He was. He was really active. He was the song leader. He always made it into a role in the church. So he was a song leader. When he would visit in New York, and if we sang a new song that he didn't know, he would record it and go teach it back to Dallas West Church of Christ. So he was very active in the church. He also taught the youth ministry that was on Wednesday nights. He started that as well.
May I approach the witness, y'all?
Yes.
I'm showing you what's been marked for identification purposes of State's Exhibit 336 and 337. Do you recognize the people in 336?
Yes.
Okay. And 337 contains videos in which I showed you earlier, correct?
Yes.
And those videos of both them singing? Is that correct?
Yes, it is.
Okay. And there's 336 and 337 to the bench for any objection.
No objection to 336 and 337.
They're both admitted.
Permission to publish, Your Honor?
Yes.
Alyssa, when was this photo taken?
This was in December 2012.
And who's in this photo?
Myself, Brent, and Botham.
And this is Miss Allison's
3 children.
3 children.
Yes.
And Brent was very young on this photo.
Yes.
Thank you, Your Honor. And this is State's Exhibit 337, titled Bold Singing No. And I'm going to play Bold Singing 3. And so, those are the only two I'm going to publish on.
Okay. Thank you.
Alyssa, I saw you put your head down.
Yes.
Are those hard to watch?
His voice.
It's hard to hear his voice.
Yes.
And when you hear his voice, what do you think? How does it make you feel?
That I want my brother back.
You can just hear that voice and talk to that voice. One last term?
Yeah. Like if I could just continue our conversation, our last conversation, just not let him hang up the phone.
I have no questions.
Mr. Reeves.
No objection.
No objection. Thank you, Ms. Reeves.
At this time, Your Honor, the state would like to offer and admit into evidence State's Exhibits number 356, 355, 354, 353. Junior Defense Counsel for objection.
Judge, we re-urge the objections made earlier as to exactly as articulated in front of the judge. We re-urge those objections to each exhibit at this time.
All right, those objections will be overruled.
Judge, permission to publish.
Yes, ma'am.
State's Exhibit number 353 contains an extraction of the defendant's cell phone, and these are text messages from January 15, 2018 at the MLK parade. Text message sent to the defendant asked, "Are you working this parade?" Other messages came in from the defendant. "Yes, grandsons are on the other side if she can get through." Other message, "Where's Justin's number? Can you ask him if he told this lady?" Another message, "Held on, I worked it for 10 years, I'm good." Another message that came into the defendant's cell phone says no. A message sent out said, "LOL, dang, yep, you deserve to have it off. Was hoping you were just to say hi, miss y'all." Message sent to the defendant, "Miss you too." Message sent to the defendant, "When does this end? LOL." Outgoing message from the defendant, "When MLK is dead, ... Oh wait, ... Incoming message says, "Ha." Outgoing message, "Geez, 2.5 hours on 3 hours of this." Incoming message, "You could have met one, LOL, next time." Incoming message, "Standing at Hardwood and MLK on opposite end." Outgoing message, "Just push them or spray with your pepper spray in that general area." State's Exhibit number 354. Again, an extraction report from the data from the defendant's cell phone. This is dated September 4th, 2018. Incoming message, "Do you know what you need? A German Shepherd." Incoming message, "I happen to have one for you." Incoming message, "She's not very smart, but she'll love you." Outgoing message, "LOL, is it your dog?" Incoming message, No, it's your dog." Incoming message, "Although she may be racist." Outgoing message, "I wish I could have one, but not in this apartment. Smaller than my old one." Outgoing message, "It's okay, I'm the same." Incoming message, LMAO. Outgoing message, "I hate everything and everyone but y'all." Outgoing message. Ranger would be eaten alive. Incoming message. Ha ha, no you don't. State's Exhibit number 355. Again, this is an extraction report taken from the defendant's cell phone, dated March 9th, 2018. Text from Martin Rivera. Incoming. Damn, I was at this area with 5 different black officers. Not racist, but damn. Outgoing message. Not racist, but just have a different way of working, and it shows. Just a moment, Your Honor. The state would like to offer into evidence State's Exhibit number 401 and State's Exhibit number 357, 358, and 359, tendering to defense counsel for objections.
What was 359?
359 is going to be one of the social media posts.
Judge, no objection to State's Exhibit 401, the business record with a single page.
That would be admitted.
We object to State Exhibit 357 pursuant to Rule 901 of the Texas Rules of Evidence, as well as 401 and the balancing test in Rule 403, Your Honor. And object to State's Exhibit 358 pursuant to Rule 901 of the Texas Rules of Evidence, as well as under 401 and the balancing test under 403. And defense objects to State's Exhibit 359 pursuant to Rule 901 and that these are not properly authenticated, and under 401 and the balancing test of 403.
And permission to publish these, Your Honor?
Yes, ma'am.
All right, I'll hold those. And then just one more, Your Honor. The state will also like to offer at this time State's Exhibit number 400, tendering to defense counsel for objection.
Your Honor, State's Exhibit 400 is the application processing unit records for reasons stated previously on the record.
Your objections are overruled.
And permission to publish.
Yes. Thank you.
State's Exhibit number 400, under business records affidavit, are records from the Dallas Police Department in their applicant process unit. Dated for August 23rd, 2012. The defendant's name, Amber Guyger. Preliminary interview for the Dallas Police Department. Page 2, Section 3. Question B, have you ever applied with any law enforcement agency, fire department, or related work, including cadet or explorer? Yes or no? Circles, yes. Date and position applied, approximately June 7, 2012, to the Fort Worth Police Department. Fort Worth. Denied, police officer. Approximately July 15, 2012, DFW Airport, police officer. Page 4 of State's Exhibit 400. Drug usage. A, have you ever smoked or experimented with marijuana? Circles, yes. Number of occasions, 3. First used, July 2009. Last used, June 20th, 2011.
Thank you.
Last page, drug usage. Dates used, July 2009. Last used, June 2011. First time, July 2009. Second question, total number of times used, 3. Ever bought? No. Ever possessed more than 4 ounces of marijuana? No. Narrative. First tried right out of high school with friends. Then in 2011, two times, 2X, friend's birthday. Again, dated August 23rd, 2012. State's Exhibit number 357. Taken from the defendant's Pinterest account. And it states, I wear all black to remind you not to mess with me because I'm already dressed for your funeral. The bottom of State's 357. Amber with a smiley face, saved to love to laugh. Comment, yeah, I got me a gun, a shovel, and gloves. If I were you, back the fuck up and get out of me fucking ass. State's Exhibit number 358. States, stay low, go fast, kill first, die last. 1 shot, 1 kill, no luck, all skill. At the bottom, it says Amber, and the comment says Navy SEALs. Saved her quotes and inspiration. State's Exhibit number 359. States, people are so ungrateful. No one ever thanks me for having the patience not to kill them. At the bottom of State's Exhibit number 359, Amber, smiley face, save the love to laugh, comment, grateful minion.
Yes.
I'm Tanya Iser, investigative reporter here at Channel 8. I'm joined by Justin Moore, a Dallas criminal defense attorney. Some pretty controversial text messages that we've seen, and Pinterest as well.
Wow, yeah, those text messages are definitely working against the interest of Guyger and her defense. Very inflammatory. She discusses MLK, the MLK parade a few years back. She was asked when the parade is over. She said when MLK is dead, ... Wait a minute. She talks about using pepper spray to move folks at the parade back and away from other officers. And she talks about a racist dog and wanting one. She talks about the work habits of her black police officer colleagues, all inflammatory, and they all look bad for Mrs. Guyger in front of this jury. I don't know what her defense might be thinking right now. I mean, they tried to object to those
They had to
text
keep it
messages.
out.
Yeah, understandably so. They don't look good for her. I mean, what we've seen in this line of questioning and punishment phase is we've seen the state eulogize Botham Jean further, provide character evidence of him being a great person, an awesome worker at PricewaterhouseCoopers, someone who is just a beacon to the community. But you've also seen them continue this character assault of Ms. Guyger. Her character is on trial, and they're really going after her with these text messages.
It's kind of no holds barred.
It's no holds barred. It's, oh my God. I mean, they're painting her out to be worse than she looked during case in chief last week.
And something that Botham Jean's mom said, she said, my life has not been the same. It has been a roller coaster. I cannot sleep. I cannot eat. It's just been the most terrible time for me. How effective do you think her testimony was?
I mean, I think it's important to put yourself in the shoes of a mother who has lost a son. I don't have children, but I witnessed my mom lose my brother.
See what's happening.
All right.
I'm sure you're going to go play cards with that. You already see it. You can go and
So the judge has left the courtroom. It looks like we're on a break. It wasn't really said audibly, at least that I caught.
Right. Yeah, it appears so. Judge just walked out. Looks like she released the jury. It might be their afternoon break. Mrs. Guyger still looks like she's sitting down there, so I don't think they've recessed for the day, so we can prepare for them to come back and hear more testimony.
We haven't spoken since the verdict came down this morning. What was your reactions to this verdict?
I was shocked, honestly. I mean, just taking the evidence as it is, or as it were, I was fully expecting her to at least get a manslaughter charge. I thought the murder was going to be a tough order for the state to get to, but I mean, they got to it. I mean, we saw a beautiful close from Jason Hermes and Jason Fine yesterday. So I think what they were able to do is they were able to effectively appeal to the emotions of the jurors, let them know that this type of crime, how heinous it is, it should not go without being punished. And I think they effectively laid it out and laid out the reasons why the jury should find Ms. Guyger guilty of murder.
Hermes was once your supervisor.
He was once my direct supervisor when I was a DA a few years back. Incredible attorney. I mean, you saw some of the things that he did in trial, which is, he got up in Mrs. Guyger's face. He appealed to direct emotion, but he also used cogent and tight logic with his arguments. These are all things that he taught us when I was a young prosecutor, and he's doing that in a very masterful way in this trial.
It's just been this whole trial, the prosecution has really been on their game.
Oh yeah, I mean, this is their A-team. You know, Judge Cruzo, DA Cruzo, he found the guys in his office and girls who know what they're doing. They've seen these cases. They've taken their losses too in previous cases, one being the Derek Wiley case, and they saw what worked and they saw what didn't work. And one thing that they saw that did work was, fully and effectively and aggressively going after expert testimony. Expert testimony, a lot of times, that's what, a lot of these not guilty verdicts come from, is when you have these expert witnesses take the stand and say that officers' actions were reasonable. So what they did in this trial is they aggressively attacked that and made sure they couldn't get that testimony in. The DA's office, they've shown that they have put in the work and the effort to get the verdict that the community asked for, and they should be applauded for that because it was a tough order for them.
Is Amber going to have to take the stand again?
She's going to have to get up there and, we talked about this during break. She's going to have to beg to make sure she doesn't get a full 99-year sentence. I think it's not likely that she'll get a full 99-year sentence.
Yeah.
But, then again, this jury has shown that they're willing to defy convention and make the hard decision. And, you can kind of talk about, or you can kind of argue about their decisions are right or wrong, but I think they're showing courage, at least going with their gut. So we don't know what's going to happen at this point. The evidence that we've seen in the punishment phase is damning for Mrs. Guyger. So, ultimately, the defense is going to have a hard job or a tough job trying to get them back to level and look at this, this evidence that's being presented to them in a way that's not going to completely put Ms. Guyger behind the 8-ball.
What do you think's going on here? We're watching the judge has left the courtroom, Amber Guyger's. We see her attorneys.
They're huddled around her. I think they're getting ready to put her on the stand.
You think?
Yeah, that's what it looks like. Typically, defense attorneys don't huddle around their client unless they're getting ready to put them on the stand. So I think they're talking to her, making sure she can get up there and maintain her composure, touch the notes that she needs to touch because it's going to be vital for her life. So they want to make sure she's up to the task.
It was interesting that we didn't see opening statements from either side. Normally in a punishment phase, it's kind of like the guilt innocence. You
right.
See opening statements. Why do you think we didn't see that?
Well, I think both sides have introduced themselves to the jury. Everybody's well acquainted with each side. They understand the issues already. So, it's better to not inundate them with extra, stuff, so to speak, and get into the meat and potatoes of the punishment phase. So I think they just decided to forego that and just and they wanted to just put on evidence so they can get this out of the way and, move on with this part of the trial.
We've had some folks who've missed the text messages. What are the key things that we saw in those text messages?
Boy, those text messages, wow. If there was any scintilla of
you could see why they wanted to keep them out of guilt innocence.
Right. If there was any scintilla of sympathy for Miss Guyger that the jury might have had, and the state is chipping away at that. Those text messages are so inflammatory. From the MLK parade text to the German Shepherd and the dog being quote unquote racist, to Miss Guyger talking about using pepper spray as an option to get parade goers out of a fellow officer's way, to her talking about her fellow officers who are black and their work habits. It's just damning, all the way to the Pinterest account posts and the things that she liked, how she talked about shooting first and killing before being killed without provocation. It just looks terrible, and I see why the defense wanted to keep that out, but they couldn't, and this was a Mack truck waiting to hit them in the face, and it's hitting them right now. I can't imagine what they're telling Ms. Guyger right now in lieu of her taking the stand. Last week she owned up to her actions in that apartment. She's gonna have to own up to these texts. She's gonna have to own up to the Pinterest account activity. I don't see how she's gonna own up to it in a way that makes the jurors like her anymore. But she's gonna have to do it. So I don't want to completely say it's impossible, but she's going to have a tough road ahead of her.
Somebody's asking if we'll see a sentencing today. Like, Explain to folks just kind of how this process works, what we're watching.
Yeah, so, judges.
Oh, judge is back on the stand. We don't have sound yet.
It looks like the jury.
I don't know if you think she's dismissing them? We
Still
still don't have
calisthenics.
sound. The judge has made it very clear we're not supposed to, we don't get sound when they're not on the court, when they're not on the record. So the judge is conferring with the attorneys. It's really impossible to know exactly why.
Mm-hmm.
Any thoughts on what they might be doing here?
Housekeeping measures, maybe discussing some evidentiary issues. But let's get back to what sentencing is. So what the state is doing, they're providing victim impact statements. You've seen testimony from Botham Jean's mother, Botham Jean's sister. You've seen testimony from his supervisor at PricewaterhouseCoopers, all detailing how great of a person he was. He was a benefit to the community. So that's what the state is doing. So that we call that aggravating evidence for the defendant. They want to show the jury that Ms. Guyger took away someone who was deserving of still being here, someone who never should have had this happen to. So that's what they want to do. They're pulling at the emotional heartstrings of the jury.
Pretty effectively.
Effectively. What the defense is trying to do is they're trying to provide mitigating factors. They haven't really gotten into it yet because we're still going through the state's evidence, but they're trying to get them on rebuttal and trying to minimize the damage. I don't know if they're effectively doing that. Oh, also another thing, they had Sergeant
Watson.
Watson on, Ms. Guyger, CRT supervisor. His testimony was important because it shows that her propensity of telling the truth, her propensity for mendacity is in question because she lied about an issue that he had to refer to internal affairs a few years back when it came to a handcuffed suspect actually fleeing away from her and her not reporting it to her supervisor. So when she takes the stand, the jury is going to take that into account. Can we actually listen to her testimony and find it truthful?
Right.
So I mean, it's character evidence that's really going to hurt her going forward. I mean, they have a tough road. I mean, going into today after the verdict was rendered, we thought that her defense counsel should be able to effectively convey to the jury that she didn't deserve a maximum sentence. It's still going to be tough to get that 99 years. I'm sure the state's going to ask for it because they're hitting her pretty hard with this evidence. But I know we opined before, and a few other folks said that she might have a 5 to 10 year sentence. With each damning piece of evidence, you're going to add some more years to that, I suppose. So, which also goes to another issue if she gets the appeal bond or not, right?
Well, no, we know
she won't be able to get it. Oh, yeah, right. That law changed.
We haven't talked about that.
Yeah, that law changed.
There was a change in the law. To explain to folks this change in the law that everybody in the legal community is finding out about today, it seems like.
Right. So the change occurred in 2017. So typically, if a person would have had a sentence under 10 years, they would have had the ability to get an appeal bond in which they would not be taken into custody and they could wait out their appeal within the comfort of their own home. That law changed in 2017. So she will not be afforded that opportunity. So, at the end of this punishment proceeding, she's going to have to go, or be taken into custody, and she's going to have to wait out her appeal while in custody, which is a complete difference of what the standard used to be. I don't know why the Texas legislature made that change in 2017, but they did. And, we're seeing this being played out with Ms. Guyger. She won't be afforded that ability to go home like other defendants have in the past.
Yeah, it's kind of surprising that nobody seemed to know about it until today. I mean, everybody I talked to really thought that was the rules, and somewhere along the line, well, we know it changed on January 1st of 2017. There was a change made. And maybe it's just because typically in murder cases and cases of this type, you wouldn't typically get less than 10 years.
Right,
so it's not really an issue that arises that often.
It doesn't really arise. I mean, typically in murder cases, folks don't get less than 10 years. I mean, you think about it. They've already proven that it was an intentional murder. There was there was mens rea involved there. So typically you see folks, they don't even get close to getting a sentence under 10 years. But with this situation, you have an officer. It's been considered because she's been classified as someone who has been a credit to the community in the past. So I think we just readily assumed that it was a possibility that she would get a sentence under 10 years. So that's why we thought about it. But ultimately, and it's always hard to keep up with legislative changes of the legislative landscape. So a lot of times that slips past a lot of attorneys. But here, I think we're educating folks right now. I mean, I was talking to somebody the other day, like covering this case is almost like a CLE, continuing legal education course, because we're picking up on small little nuances that only would come up in a case like this.
Right, mistake of fact, and
Mistake
just
of
all
fact,
these
right.
issues that we wouldn't normally talk about.
Or the issue of her possibly raising this defense of what is the defense? I'll read it from the statute. At the punishment stage of a trial, the defendant may raise the issue as to whether he or she caused the death under the immediate influence of sudden passion arising from an adequate cause. What's important about that is if the defendant proves the issue in the affirmative by preponderance of the evidence, the offense is a felony of the second degree. So, I mean, if they can effectively raise this issue, we might see the punishment get pushed back down to a second degree felony, which would make her eligible for probation.
But who would make that decision?
The jury would. The jury would make that decision. And from what we've seen, this jury is they're pretty gung-ho.
If they wanted to go with a second degree, they could have gone
They
with
could have done
manslaughter.
that. Yeah, they could have done that during guilt or innocence. But, you never know with these punishment phase issues. That's why it's part of the statute. It's still a caveat there for defendants to kind of latch onto as a last-ditch effort to keep them out of prison. So I don't think the legislature would have put that in there if it wasn't a possibility. It's going to be, I think it's a long shot for this case, but nevertheless, it's still a possibility, and you're going to see our defense team try and use that argument going forward.
What do you think the key factors were that made the jury go, okay, she's guilty of murder? What were the things that made them say, okay, this is the appropriate conviction?
It's really hard to say. I don't know what they were deliberating on back in the jury room. But I'll say this, I mean, the state's closing argument was just compelling. I think it was more compelling than the defense. Typically the defense, they just have to poke holes in the state's theory. They don't have to really provide some, groundbreaking, a piece of evidence that will, save their client, because ultimately the burden is on the state. But I think what the state was able to do with their fabulous prosecutors is they're able to really paint Ms. Guyger as someone not deserving of leniency, right? I mean, Mr. John was in his home eating ice cream on a Thursday night watching football, and he was murdered in cold blood. We can call it murder now because she's convicted of it, right?
She is convicted.
And I think really, you saw Jason Hermes kind of just nail this point on the wall. That's inexcusable. There's nothing that you can say to excuse that. She tried to use this whoops defense, which was the mistake of fact. I just think the jurors they came to the conclusion that that's not good enough. We got to be safe in our own homes. So I think that's really what it hinged upon.
Well, and if they had agreed with mistake of fact, then you would have had the Castle Doctrine kind of turned on its head.
Right, precisely. The Castle Doctrine would have came into play, but I think, for one, those are two confusing issues for the jury, and they might have worked it all the way through, and they probably said at the end of the day, these issues are nebulous and confusing, and it's too cloudy for us to even go to that part of the argument for the defense. Let's stay somewhere where we're sure of, which is this is inexcusable. It might not be a cogent legal argument, but at the end of the day, that's why you have folks from the community serve on these jury panels, because they bring some type of logic and common sense that a lot of times as lawyers don't think about. We think about things in a very nuanced and very, closed off type of way, almost a lot of times devoid of common sense. It's all based on case law and precedent, which might not take into effect the ethos of society that's going on at the moment, the social milieu that's currently permeating through a community. A lot of times we look at things devoid of that, but you got these community folks coming in, they understand how they feel and how they would feel in that position, and they probably made a decision saying that if I were Botham Jean, I would want this person to be held liable for murdering me in my home. And I think that's where the decision basically ended up coming from.
So we've been watching here in the courtroom. One of the prosecutors was talking to Botham's family, and it's kind of confusing what's going on. The jury's
Yeah.
not in there. We can't really tell, are they wrapping up for the day, or it's kind of...
It's really hard to say.
And with them having the mics off, and again, that's something that the judge has made very clear, that we cannot have mics on when the court is not on the not in session. Someone's asking me, will she get to go home today? No.
No, she won't.
She's been convicted. She does not get to go home.
She is a convicted murderer. She will be going to Lou Sterrett tonight.
And she'll be booked in, and there'll be booking video of that.
Right. That's going to be compelling to see too. We already have one booking video of her
from Kaufman County, right? When she was
Kaufman
booked
County.
on the manslaughter charge.
Right. This is all remarkable, Tanya. I mean, this is something that we've never really seen before. I mean, we've seen it sporadically in certain pockets of the country. We've seen certain officers.
Well, we've had 2 convicted in Dallas County.
Oh yeah,
That's
well,
true.
Roy
I mean,
Oliver
and Ken Johnson.
Yeah, this
certainly
is true.
the first female
Right.
officer. That's certainly extraordinary.
Right. And I think that's across the country. We haven't seen a female officer get convicted of
No,
murder
this
yet.
isn't. And of course, the facts of this case were extraordinary as well. I don't think anybody that I know can recall a case like this.
Right. I mean, yeah.
Just the fact pattern.
The fact pattern is wonky. This is something that you see in law school. This is a fact pattern that your law professor thinks up of, in lieu of a semester starting, wanting to be cute. This is a fact pattern that's very bizarre. It's a lot of issues here that you got to kind of be creative about. And kudos to the attorneys on both sides for coming with arguments that actually made sense. You can tell they tried hard on both ends. But yeah, to your point, this is something that we've never seen before.
Do you think this will be taught in law schools?
Well, so this issue is going to be taken up on appeal. So if it gets to an appellate court and we get a decision that sets a new precedent, it will be taught. But as of right now, I don't see this being something that a professor is going to really teach in law school, at least not in a criminal law course.
So that guy right there, that's Mike Mola. He's the appellate attorney for Amber Guyger's team. What do you think they will be bringing up in an appeal in this case?
The issue of the expert testimony being restricted. I think
Change of venue, probably.
Change of venue. Some of the text message issues. Honestly, I think the expert testimony issue is something that's going to be brought up because, from the Sixth Amendment perspective, every defendant should be able to provide the defense that they find to be appropriate for their case or for their trial. And the fact that judge restricted that expert testimony, I can see her attorneys using that as an appealable issue going forward.
Will it be an effective issue?
It's hard to say. I mean, the Texas Criminal Court of Appeals, those folks are elected too. You don't know how they're going to sway on that. I mean, politics is still going to be involved in that too.
Well, in courts and appeals courts are loath to overturn trial judges.
They're loath to overturn trial judges.
Not to say they won't, but they're loath to do it.
In situations where a defendant is saying that they weren't provided every opportunity to present their defense, appeal courts or appellate courts have always, well, not always, but have typically ruled in the defendant's favor on those issues because you want to maintain their Sixth Amendment right to an adequate defense.
Do you think they'll bring up change of venue? That she lost change of venue?
Well, it was rumored that some of the jurors said they had their minds made up before the trial started, which speaks to the venue issue.
Some of the jurors that were picked?
Yeah, I mean that's the rumor. That's the rumor that I'm hearing. It hadn't been substantiated, but if that is true, even if it's just a rumor, I can still see her defense team raising that as an issue. They're gonna give the whole kitchen sink defense when it comes to that appeal. So it could be an issue. It might be something that doesn't have any teeth to it, but you can see them just trying as hard as they can to keep Ms. Guyger out of prison.
John Fuels asking to explain why she. Well, he was saying it went too fast, but basically she can't get probation. Explain why.
Well, she can't get probation right now because she's not eligible for probation.
Right.
Her charge does not provide any opportunity for it to be probated. But as we talked about, if she raises this defense or this issue, and the issue was, what do we call it? Issue as to whether she caused the death under the immediate influence of sudden passion arising from an adequate cause. If she raises that and the jury finds it to be something that is justified, her murder charge could be taken down to a second-degree felony, which would make her eligible for probation.
That seems so unlikely.
It seems unlikely, but I mean, it's in the statute, so it's something that she can argue for
Well,
sure.
and frankly, until you brought it up, I had no idea that existed.
Yeah.
Appreciate it. Thank you so much. 8:30? 8:30 now.
Yeah.
8:30?
I mean,
9:30.
I'm not saying it's likely. I'm not saying it's unlikely, but as a defense attorney, you gotta know your statute so you can adequately represent your client.
Does it look like they're wrapping up for the day?
That's what it looks like.
It looks to me like they're saying either 8:30 or 9:30.
All right, they're wrapping up for the day, and
It would appear so.
they're going to get into more testimony tomorrow.
You think the prosecution was done?
I don't know. We haven't gotten word yet. I would assume so, because when you saw Ms. Guyger's attorneys huddling around her, it seemed as if they were prepping her to take the stand again. So it seems as if the state might have been finished. It's so hard to tell because we don't have mics on the counsel tables. I think there's only mics on the jury box and on the witness box. So it's really kind of hard to get a clear understanding of some of the stuff that goes on or that's been going on. But if I would have to guess, I think the state rested their portion of testimony for punishment.
Yeah, they didn't say. It all kind of happens so quickly. Now we've gone back to the state of Texas seal. You think they're taking Amber Guyger into custody right now, maybe?
I would assume so. I wish we could get a shot of that. But I don't think she's being released to go home tonight. So I think she's going into loose there. I think they're taking her into custody. I think she's going to go back into the vestibule, which is between the courtroom and the hallway. They're going to talk. Her attorneys are going to talk to her. They're going to discuss what's going to happen tomorrow, and then she'll be taken into custody, and she'll spend the night in Lucerne with the thousands of other unfortunate souls that we have in this county spending the night there too. So,
you think they're we're going to put her in protective custody or something like that?
Oh yeah, she won't be in general population. She won't be there. I mean, it's too dangerous. They'll have her in an isolated cell. She won't be around anyone that could cause her harm, because I'm sure there's a lot of folks in Lucerne that might not find it to be something that they would like to have with an officer in jail with them tonight.
Well, let's just kind of recap today. So Amber Guyger this morning found guilty of murder. The jury had two options. They could have convicted her of murder or manslaughter. They came back after 6 hours. They deliberated 4 hours yesterday, 2 hours today. It came back around 10:45 this morning with that verdict of murder. Now we've seen about 4 or 5 witnesses. We've seen his mother. We've seen his sister. We've seen his supervisor, Amber Guyger's supervisor, and some emotional testimony this afternoon. And of course, some text messages and some Pinterest that really kind of provides the contrast between these two people.
Yeah, damning evidence, those text messages and that Pinterest activity. I don't know how Amber Guyger's team is going to get over that. It looks terrible. What they want to do in punishment, and I think what they were looking to do, is to provide character evidence and testimony that made her more sympathetic. But what the state provided, I think there's more stuff that's being piled on her. So they're going to have a tough time trying to come up with something that makes her likable tomorrow. I just don't see it. I mean, I think the murder conviction that we got was based on her likability or unlikability, and the state is just continuing.
Facebook said they didn't like when I said that. But why do you say that?
Well, I mean, I think it's just what we've seen is it's a circumstantial evidence case. So when you have circumstantial evidence, it really boils down to who you like the most, because it's really hard to say what happened in that room.
Because there's two people that know, one's dead.
One's dead, and the only person here to tell what happened is someone who's not likable. She's not believable, based on those text messages and her supervisor's testimony today. There's no reason to believe her. Even he doesn't believe her. At least in that incident that he referred her to Internal Affairs, because he could have chosen to have more private counseling with her, but he chose that Internal Affairs is more appropriate Why jump all the way to that if you feel like your officer doesn't have the propensity of telling the truth?
Well, I will say that when a handcuffed prisoner gets away from an officer, that almost always triggers an internal affairs situation, because it's a big problem when a handcuffed prisoner gets away. But she didn't tell her supervisor, and that is a problem.
I think that's what he said. That's why he referred it to internal affairs, because she didn't tell him about it. But so, and you know, they're going to have a tough time. I think, like you said earlier, or like we talked about earlier, what the state is continuing to do is to make Amber Guyger seem to be a monster, and they're just continuing to hone in on that. I can only imagine what Ms. Guyger and her team, what they're going to present tomorrow. You probably can expect testimony from her mother. You're going to expect testimony from Ms. Guyger. I don't know who else they can put on the stand. You know, you have some of her CRT team members. You can't put them on. Martin Rivera, I think he's a wash. Not a wash, but he's probably the worst witness they can put on.
Well, that would be a whole different set of problems for them. And I don't know that they really want to go back down that path.
Right. What I'm really curious and interested to know is, how is she going to explain those text messages? I mean, they
do look bad.
She owned up. She owned up to that activity in the apartment last week. She owned up to that. But how is she going to own up to these text messages? I mean, it just doesn't make sense. This whole MLK thing. Oh, the parade's going to end when he dies. How insensitive is that? Or talking about her black, officer colleagues, saying that their work habits are below standard, casting this racist trope that black people are lazy. I mean, I just don't get it. And I see why her team fought so hard to keep that evidence out, because it's completely damning.
Right, because they originally wanted to get it into the guilt and innocence portion of the trial.
Yeah, Jason Hermes tried to sneak it in, and that's when you saw Mr. Rogers, her defense attorney, immediately pop up and ask for a sidebar. And now it's getting in, and it's not helping her.
How important do you think the ice cream and the red rug was?
I mean, a lot of times, in trials, you're telling a story, right? So you have these symbolic, like symbols that symbolize something greater than what you actually see in the text of a story. These things represented something that I think truly affected the jury in a very visceral way. The ice cream, it signified just the humanizing,
I'm sitting at home eating a bowl of ice cream.
Right, yeah. I mean, we all have long days. I mean, you talk about your long days throughout this course of the trial. You just want to get home and decompress. A bowl of ice cream is so symbolic. It made Botham Jean seem innocent. And he is innocent. But I mean, that bowl of ice cream, the red doormat, I mean, those things really, I believe, affected the jury in a way in which they said, we cannot let Ms. Guyger get away with not having a conviction for this incident.
Well, and she had tried to contend this mistake of fact thing, and then there was all this testimony from neighbors who said they went to the wrong apartment and this, that, and the other. But basically, what do you think it came down to on that when the jury started considering all that testimony?
Honestly, I think they might have conceded that she made a mistake, but I think how she responded to that mistake, that's what the jury honed in on. Because you can make a mistake and go to the wrong apartment, and we've seen numerous folks testify to that. But once she got to that apartment and she saw who was in there, I think that's what they're judging her on. If Botham Jean had been somebody else, had he been of a different race or of a different gender, would Ms. Guyger would she have pulled a gun or a weapon and shot him? I don't know. I think the jury said that she probably wouldn't have, and the reason why she did shoot him was because he's black and male. I think that's what the jury, and we haven't spoken with the jury, but I think that's what it came down to. Had Botham Jean been somebody else of a different gender and race, we probably would not be here today. And I think that's what the state honed in on, and I think that's what they played with. I don't want to say play with because it diminishes the seriousness of it, but that's part of their argument, and that's how they were able to be effective in getting the jurors to have an emotional connection with this case.
The issue of her police training, how critical do you think that was to the jury?
Well, you saw Jason Hermes, and I think he did a fabulous job in kind of just detailing training and the importance of it, because he's a former police officer. So I think the reason why he was so able to talk about training in a way that was kind of almost second nature to him is he has been trained. So he talked about, you know, the observational training that an officer has, especially someone that worked in the CRT team. He talked about how an officer is trained to have some sort of awareness that's different from a layperson. Training was important because although she thought she made a mistake into going into her own home, she has been trained to be aware of things that the average citizen isn't.
Right.
You can't turn that off.
Right. It's just part of who she is. They're going to be taking us live here in a few minutes on our 4:30. Nick, do we have an ETA on that? 60 seconds. 60 seconds, okay. So we're going to be kind of kicking it off again for the folks that are watching us on TV, and we'll just kind of chit-chat until we go live.